So much for being here. My name is Rebecca Weininger, and I'm not the executive director. That's my Susan Schulman. I'm the director of the domestic violence law practice at the North Suburban Legal Aid Clinic. And I am so thrilled to have a conversation tonight with some of my closest friends. Paula Meyer-Bessler, you are the managing attorney for the Civil Division of the Chicago Alliance Against Sexual Exploitation. Thank you so much for being here.
Thanks. It's an honor to be here. Thanks for having me.
Jessica Finley, you are a staff attorney for Prairie State Legal Services. Megan Brady, you are also a staff attorney for the Prairie State Legal Services. Thank you so much for having this conversation with me tonight. And Jeanette Tinoco Ledesma, you are the Director of Legal Advocacy for a Safe Place. Thank you so much for being here. I'm really excited to have a conversation with you guys about the court process that protects survivors of trauma, the people that we work with. And I would like to start by just asking you how the court system is failing survivors in Illinois. Paula, can you talk about, in your work, what you've seen as the failures of the court system?
Well, I think so much is that you can't separate it right now from COVID. There's so many ways to make this easier for the survivors that we're dealing with every day, day in and day out, and that is not happening. First of all, there's really not consistency within the courthouses, whether it's at 555 or in the suburban courthouses, for survivors or victims to access the courthouses. And then when working with advocates, they're bringing advocates into roles that really they should not be playing, or having their identity disclosed on the record, or all the multitude of issues there. Also trying to get service on the perpetrators, respondents. There's issues throughout that. Again, there's lack of consistency throughout all of that. And the ability from everything from just even the timing, like in an emergency. Let's take for an example, an emergency. Well, hello. An emergency order petition, you know, they try to now indicate that something has to be done either in person or by a certain deadline. And then it's not even going to be heard until the next day. That has been greatly changed, which is very much to the detriment of someone who needs immediate protection. And those are just some of the initial things that we're seeing in trying to get a consistent order throughout the courtrooms. Has been very challenging, and we have a whole coalition of wonderful practitioners and advocates and rape crisis counselors that are working to try to find solutions for that, but it is an uphill battle, of which does not need to be there, especially 7 months into the pandemic.
Megan, can you talk about, you know, can everybody mute themselves? Can everybody who's not on the panel mute themselves? Thank you. We talk about the differences between domestic violence court and family court. Megan, in your experience with survivors, can you talk about how those two kind of competing courts, there might be whole gaps in protections that we can get for survivors because of the, you know, sort of cavern that there is between those two courts?
Sure. You know, I think one of the most important things is to remember that anybody who comes to us has experienced a traumatic event. And the way the legal system is set up, you know, it's set up to solve problems, but not effectively deal with trauma. And that isn't the starting point ever of where the court is. And when we talk about the intersection of what you can get as far as an order of protection or a civil no contact order compared to what's available in family courts, oftentimes the orders of protection are band-aids on bigger problems, and there's so many other issues. If we just take the issue of a survivor and her abuser who have children together, and you look at the number of things and the number of decisions that have to be made on behalf of those children by two people that have a dramatic power imbalance, and one of whom has suffered, at least one of whom has suffered significant trauma, there's going to be a huge disconnect. And the system as it is, the court system, just isn't set up to deal with that issue at all. They do their best, but the framework just isn't there. And so there are many, many times that we find ourselves saying, you know, you might be able to get an order of protection here, but really what you need is a divorce and a parenting plan. You got to get a rule book in place on limits on how this person can contact your kids, when, how can they contact you? What are you going to be talking about during those conversations? How do you enforce that later on? And the order of protection can only go so far inherently. And frankly, the family case can only go so far, but you can do a lot more within those family cases. The difficult part, of course, is the order of protection. It's emergency. You have a 3-week turnaround time. Family court can take 6 months, a year, 2 years in really complex cases before you have any answers at all. And your life is completely turned upside down, and you may not have even addressed the underlying trauma that you've been through at that point.
Totally agree. And one of the things that frustrates me the most is DV courts don't seem to want to deal with family law issues, and family law courts don't want to deal with DV issues. And these things are inextricably linked. Jessica, what is the part of the process that's the most frustrating for you?
I mean, I don't know that I can point to something directly in the court system. I think a lot of the problem is more about societal perceptions and societal expectations of survivors, victims of domestic violence, victims of sexual assault. And I think that that's part of the reason the court doesn't want those two pieces to intertwine, because it makes things hard. It's hard. It's hard to prove domestic violence and just as in sexual assault, generally speaking, the two witnesses are the victim and the perpetrator. So it's going to come down to the credibility of the witnesses. It's going to come down to how well they present themselves in court. And to be honest, in divorce court, judges don't like messy cases. They don't. They want the lawyers to work it out between themselves and try to get everything done off the books and reach an agreement. And oftentimes, especially Megan and I, are working with low-income messy cases at that. So not only is the case messy, it's taking a long time over what seems like not a big deal to the judge. So I think that is frustrating, that there's not an understanding of the issues from the people on the bench and the people who are involved in the process, because domestic violence and sexual assault just make things so much more difficult to achieve results in the system that we have.
I really agree. It's an obstacle unto itself. Jeanette, you see, in particular, women, and we're talking about women. This is not, to invalidate the experiences of men, but overwhelmingly, all of us deal with women. In the moment where they have taken that step forward and they have come into court to ask for help, in your experience, what is that like in particular for women of color and women who don't speak English as a first language? What extra barriers are there in terms of racism and xenophobia, in the system that make it even harder when you layer on top of the trauma they've already been through, the fact that they are a woman of color or a woman who doesn't speak English as a first language?
Well, I think it definitely adds to the many, many barriers that are already in place for a lot of our victims, right? Not knowing the language, not being able to communicate, not only with the court system as a whole, but we're talking about from the beginning point of contact, which sometimes may be the police, right? Police come over to the home, they see someone that is calm, cool, and collected, that knows how to speak the language, that is able to explain the situation to them. And then they see someone that is obviously in distress, that cannot communicate with them. And that is part of the barrier, because by the end of it, the person that is calm, cool, and collected has already explained the situation from their vantage point. And the other person has already been left in the rain, per se, right? They feel as an outsider already. And then they come into the courthouse. They already don't know whether the police have believed them. They don't know whether what the next step is going to be or what their lives are going to be like. The amount of trauma that they have been through already, I think that's part of the hard part, that a lot of the systems that deal with domestic violence victims are not trauma informed. They have no idea that being hit may be violence, right? But what about all of the mental abuse, the emotional abuse, all the threats, all the things that they have received from the perpetrator saying, if you ever call the police, they're going to believe me and not you, right? So that has already been set up way beforehand. As a person of color that may or may not speak much of the language, right? Then they come into an environment which, if anyone has been to our courthouse, they know that it's complicated to even get to the right place and find the right spot, right? So then they have to go through that whole thing. We're lucky that in our office we are Spanish speaking, and that we can provide that services, but we've had people that are French speaking, we have people that are Korean speaking, Russian, and we have the language line to use, but they are still very afflicted by the possibility of not being understood. I've had clients that have come in and said, well, I was trying to talk to the police officer, but I don't think he understood me. Or when I went in front of the judge, I don't think I was understood, right? And I think one of the barriers is at times, as someone that does speak Spanish, right? You're listening into the conversations that are being translated by some of the people that are appointed at court, and you're like, but that's not really what is happening. That's not what she said. So then there is that thing, right, that you don't know how to say or how to address, because as an advocate in court, I cannot speak up and say, judge, that wasn't interpreted correctly, right? So I think it puts our victims in a situation that is, one, already incredibly intimidating to be in, and then you're putting them in even more traumatic role, right? Because they're not being understood. There's someone that is speaking for them that may or may not be invested in what they're saying. So they may or may not be paying as much attention as they should.
That's so many obstacles stacked against them. And Jessica, I want to go back to something you said about society, society's expectations. One of the things that I have experienced as a practitioner is the inability of some of these women to be able to make decisions for themselves, because so many decisions have been made for them for so long. And you're in front of a family court judge who's saying, you need to make this decision, you need to take this deal or not take this deal. And by the way, it's going to prejudice me against you if you don't. Another example is in testimony giving. I had a case for a plenary order of protection, a woman who testified beautifully, although, you know, with no affect, and the judge actually looked at her and said, I find you not to be credible, which was absolutely devastating. We can all see every day is how the system hurts survivors. Paula, could you talk about how the survivors sometimes hurt themselves in the process? You know, we as want to put them in the best position possible to succeed, and sometimes that relationship is really complicated.
Absolutely. And before I even answer your question, just kind of piggybacking on what you're saying, is the lack of the civility and respect for survivors and victims in the courtroom is a second epidemic to me, because just right there, that judicial instance you just shared, but also judges allowing respondents, attorneys to be so disrespectful to a victim who is strong enough and brave enough to come into a courtroom with all those barriers that Jeanette just shared and what we've been talking about here. For themselves, where they might harm themselves is in their initial petition, for whatever that is for, if they do not have an advocate or lawyer who fills that out, and then or assist them with that, where then they're locked into what their statement's there, and they might not have the guidance that would help them have the lens of what the process is through the judicial system. Because as you know, if our petition language is not strong or worded in artfully or non-legally, that can really have repercussions against the victim in the courtroom. So I think it's important to have an advocate and or legal counsel, which of course that is intimidating and a very arduous, daunting prospect for any survivor as well. But that's something that I think we all see time and time again.
Jessica, do you have anything to say about how, in your experience, the survivor has made the and that process even harder on themselves?
Again, I think this goes back to how society perceives individuals who've been victimized and what they expect versus what an actual trauma response is. Oftentimes you have people who are having a trauma response while they're talking about their traumatic event, which is exactly what testimony is. And that trauma response may be flat affect. That trauma response may be that they seem absolutely hysterical. And that trauma response may be that they are not able to create an effective timeline, which is what we like to do when we're eliciting testimony, is have it make sense to the court. So I think anytime that you don't have a perfect witness, then that witness to a certain extent is going to harm the process because, again, the court wants things to be easy and the court wants things to be cut and dried and the court wants things to be easy to figure out. And it's just not. It's much too complicated of an issue.
Absolutely right. Megan, what are some of the unpredictables in the process that you prepare your client for?
Oh boy. I think that's that's really difficult to answer because I always tell people I am giving you some of the possible scenarios, but there are 100 other things that could happen that I just cannot prepare you for. So the thing that I work really hard with before hearing with any client is packing their support backpack. This is kind of how I talk about it. You're not going to walk into court with a backpack on. They won't let you bring that near any judge. But what can you carry with you in that moment that is going to make you feel like you have some armor on, no matter what? For some people, it's how they dress. For me, when I walk into a courtroom, I always have a blazer on because it helps me, as an attorney. So what does that look like for our clients? Some clients, they have like a smooth rock that they keep in their pocket that they can sit and they can rub this rock while they're sitting in the courtroom. For some people, it's other tactile things. I had one client who was doing this for her children. For many years, she hadn't had the courage to walk away, and she was doing this now because she had older teenage girls and said, I can't do this anymore. They can't see this anymore. So she had a photograph of her children with her that she held, and that could mean different things for different people. And I try to work with them before we ever walk into a courtroom on what is that thing for you that's going to help you feel grounded in a moment where you feel like you have no control. Because we will never be able to control everything that happens. Once we walk into a courtroom, you are inherently handing over that control to a third party. So what can we do to help you find a place where you can take a deep breath and be present and know your own truth and be able to speak that in the moment? And it has nothing to do with controlling the outcome. It has everything to do with just finding their own center.
In terms of survivors of trauma, Megan, have you found that despite the outcomes, the act of grounding themselves and giving that testimony is cathartic?
It depends on the person. There are many cases that I end up, after I take the case, we get ready. People say, I can't do this. It will never be helpful for me to have to say this out loud again.
Yeah.
And so I think that for some people, it's very empowering, regardless of the outcome, right? To be able to stand there and say, I know the truth, and this is my truth. For some people, it will never feel that way. It will just feel like they're being re-victimized in that moment. And it's very important as an attorney to have that conversation beforehand of, this is what I believe the process will look like for you. And the questions that you may be asked, is that what you would like to do? Or are there other ways that we can accomplish some of your goals outside of this particular court process that may not be empowering for you, but are there other ways that we can help you find that?
Jeanette, we have moved into bizarro world with the effects of the pandemic. And one of the ways that the world has turned upside down is that we appear now on Zoom
Yes.
for court. I have found a very mixed bag in this world of first being able to say to survivors, you don't have to be in the same room, abuser, but simultaneously really struggling with the issue of credibility over Zoom, because there's something about being in the same room as someone who is giving testimony that the judge can feel that doesn't come across when that survivor is sitting in their living room. Can you talk about what you've seen in terms of the interactions between the judge and the survivor as we've gone into this world of online testimony and petitioning?
Well, I think it has definitely complicated things in different ways, because now we're dealing with not only the factors that we had in place, right? But the person coming into court, speaking in front of the judge. Now we are dealing with whether technology is working, right? If their device that they're using is working appropriately, then the judge is going to be able to hear what they're saying. If Zoom is working for the court, then it's wonderful, because then the judge can see and hear everything. There's times in which the Zoom thing is just not working, right? Then you go into the fact that if all of those things are not working, right? If our client has a device that is faulty and keeps cutting off at some point in time, then there's frustrations that build on both sides, and that is going to influence how our clients come across to the judge, right? Especially if the judge has been trying to talk to this client for the past 20 minutes, trying to get him or her to fix their device or to go and access a different device. So I think it definitely has influenced, I am not going to say necessarily perceptions, but it is going to influence reactions when we are already frustrated over the technology use of part of it. And then we have to still talk about a traumatic event in our lives to a judge that is a stranger, right? For many of our clients, the first time that they tell their story is when they come and fill out the paperwork for the order of protection. So that is already incredibly intimidating. Some of them are ashamed. They feel that it's their fault. They feel that they should have known better, right? So they've already come in and done this. Now they have to go in front of another stranger who, independently of anything, right, independently of what their title is going to make a decision that is going to affect their life from that point forth, either in a very positive or negative way, because we don't know how their life is going to be influenced after an order of protection is issued or not, right? And then you have the technology component and Zoom to deal with. So it's definitely added that extra factor that we need to make sure that before our clients walk out of our office, that they are set up with their Zoom, that their device is working appropriately, or if not, have different alternatives to be able to make sure that they're heard and that they're heard adequately without any glitches per se.
And how has it changed for your interaction with survivors who are calling you to do their petitions as opposed to sitting right in front of you?
You know what? I think that there is something to be said to having a face-to-face interaction, right? You start to build that. Oops, sorry, fell out. You start to build that relationship with your client when they walk in the door. They feel heard. They feel that you are on their side one way or the other, right? When you're doing over the phone is so impersonal in some ways, right? They may be at work, so they may not be able to express everything they want to express. They may be at home dealing with their 5-6 children that are running around, and they need to find a minute to try to tell you everything that has happened, but they want to protect their privacy at the same time. So I think there's quite a few things that get lost in the process. So I still, even with everything that is happening, I would still prefer clients to continue to come in, just because I think it does help with the streamlined process of providing them referrals of saying, okay, I can see that this is really happening and you need this X, Y, and Z referral and you may benefit from this other program, right? Instead of, let's try to do it as quickly as we can because you have to get back to work.
Right. Paula, how has COVID complicated access to advocates, access to resources? How is it making everything worse? And how, in your experience, are those issues of class and race exacerbated by those issues of access?
Well, I think Jeanette just outlined some of it. It's affected across the board, as I said in my original answer as well. It is just so pervasive, and that inconsistency. I mean, we still have some suburban courthouses that are requiring the survivor or victim to come in person. I mean, and jeopardizing not only their mental and emotional health in going through this traumatic re-accounting of their experiences, but then their physical health being possibly exposed. So the inconsistency is what's very concerning for me. And for a very long time, we could not even get orders. The orders were not being sent out. There had to be a collective lawsuit against the clerk of the court to get those orders back. So certainly with orders protections or any type of order protection, to have the actual order stamped by the judge and sent out and received, especially when there's pro se victims or anyone else, they were not being received. So that was a great concern. I feel like that has improved somewhat. I would welcome anyone else's thoughts on that. But again, they're just the inconsistencies in, like, whether there can be Zoom service or service in open court, and there's one courtroom will say one thing, or a different courtroom or a different judge will have a different procedure, and then there's going to be an administrative order, and then it doesn't come out, or it does come out and everyone's kind of going rogue and doing their own thing. That is such a disservice to access for justice for these victims, compiled on with all that it takes for them emotionally to make that step to move forward for their own health and try to achieve justice. It just compounds all the re-triggering of trauma, I think, and we see it every day. And then just even sitting, and I think it's gotten a little bit better with the breakout rooms and the attending. It depends which courtroom, again, you're on, but I've seen it with the language interpreter services too. You know, we request a interpreter, take for 3 to 4 hours. Well, then you're already on the call for 3 to 4 hours because that's taken so long just to get through the call. And then there's the service that's supposed to work through the Zoom interpretation. And then we literally had 45 minutes where the judge was trying to make that work. And then we didn't have an interpreter. And then all the while, my client is sitting there, right, looking at the video of her perpetrator. So it's very across the board, on top of all the anxieties of just being in a pandemic. We know that all of domestic violence as well as the sexual assault has just escalated. The arrests for those are so low and going even lower. People are, of course, if it's domestic violence, that they're even more quarantined with their abuser and perpetrator and having to less access to justice and court system. It's really heartbreaking, but I am heartened to be amongst women like all of you who are fighting the fight on behalf of them. So we'll keep fighting.
Every minute of the day. Just any examples of the court system working? You know, was there a time that you were surprised by a judge who just really got it and you really protected someone that you were representing?
I mean, I feel like some judges are definitely more sensitive to the issues than others. They all take it very seriously, but I'm trying to think of a specific instance where I felt like really validated by the court itself. Oftentimes I'm not thinking in terms of, you know, how the judge is viewing the case, or obviously I want the judge to do the right thing, which is of course always rule in my favor. But usually I'm so much more focused on my client coming out of those situations. And as I'm sure you're all well aware, oftentimes coming out of these situations, the feeling is not joy or exhilaration. You know, you've been re-traumatized again. It's the first step on a long road if we're dealing with an order of protection, particularly if there are children involved, particularly if there's a marriage involved. You know, it's literally the first step to get through that hearing. So I think that oftentimes I'm less focused on what the court is doing and more focused on how my client is reacting to whatever the decision is. I do think on the average, at least in my experience with my clients, the court has come out on the right side the vast majority of the time. And of course, the right side means that I win. JK.
Boy, you're totally amazing. I had a case in which it was a rape case, and the judge was horrible to me personally, the entire trial, and then not only ruled in favor of my client, but when opposing counsel tried to carve out a little exception for the rapist to come pick up his children, the court said to him, "You forfeited any right to that fatherhood when you raped this woman." And we'd already won, which was fantastic, but just that little, even just that little bit extra, that he was enraged. It's something that we just don't see a lot from the judges, because they are so sort of, you know, emotional. But just that one spark was just, that's what she remembered. You know, she remembered winning, obviously, but she remembered how much she felt believed. Megan, have you had any of those experiences where the court system actually lifted your client up?
Oh, for sure. I mean, I think that throughout my legal career, I started in Cook County at the 555 courthouse, which is all domestic violence, for better or for worse. It has some perks and some drawbacks. And now I'm up in Lake County. And every judge I've been in front of has had moments like that, where they have really good human moments. You know, I think what Jeanette was talking about earlier about human connection, you know, and that's one of the things we're really missing through the computer. And you mentioned too, Rebecca, you know, it's hard. Credibility is hard through the computer, right? Because we want to be able to connect with somebody in person. And it brings a whole different aspect of things when you can see body language and you can see a judge lean forward across the bench or lower their eyes, or when somebody says something, they do this instead. You know, you can sense that in a courtroom, and there's momentum, and there's sort of this, as an attorney, I've always had an experience of walking into a courtroom, and when you're like, woo, I don't want to do this hearing today, the vibe in here is not good, you know, or the other side of it of, wow, this feels like a really safe place today. And it might be the same courtroom on back-to-back days. It just, whatever else has happened in that courtroom that day, you know? And so I've had an experience with almost every judge that I have been in front of, that they have had good moments where they really look at someone and say, I'm here to protect survivors. And if you need my help, come back, you know, or they look at a perpetrator of abuse and say, no means no, you know, and they take those very short moments to have a human connection with someone. And I do feel like a lot of that is lost right now, unfortunately, over Zoom, because they're trying to move through things in a very different way and don't have, I mean, they have a person in front of them, but in a very different way. So, I mean, judges are people, right? They want to have those human connections. They certainly have to be a neutral decider of fact. There is a formality to court that I think should be there and needs to be there, right? It needs to be a place of respect where these decisions are respected and there are rules. But I also think that those small human moments are just really what, like you said, the survivors remember at the end of all of this.
Absolutely. Jeanette, You work in the Lake County Courthouse, and there's one courtroom for DV. And in the couple years that I've been in my job, there have been a few judges. And I don't want to attack any of the judges. What I'm asking is, how does it make your job easier or harder when you have a new judge? They could come from who knows where, you know, who knows where they've been before they got on the bench. How does that affect your advocacy when there's turnover on your bench?
Well, it definitely affects our job, and we have to make sure that we can prepare our clients, right, as to what a judge is looking for when they go in front of a judge. Every judge is different in many ways, even though there's a statute that they have to follow. Again, they are human. They went to law school. They interpret the law the way they are reading it, or the way that they were taught to read it, right? Every judge that comes into the bench is different, right? Some of them are very by the law and very by the book. And if something hasn't happened within the last 24 to 72 hours, then it may not be an emergency anymore. For others, if it's a severe enough case, if it happened a little more while back, they're still okay. So it's just preparing our clients for anything that could happen. One of the things we always tell our clients is, we are not the judge. You can always try to file, but this is usually what our judge looks for, right? So with the turnover, we have been very lucky, even with all of the different turnover, that we have been able to speak to each one of the judges and have been able to ask questions when we need to. And that each one of them has been very receptive to say, okay, if I give you this kind of scenario, what can you tell me, what type of thing are you looking for? So each one of them that has been in our courtroom, independently of the turnover, has been very willing to talk to us and listen to our questions and our concerns. And there have been times that we have asked them, what were you looking for here that we didn't see? We thought that this was a home run, and it wasn't, right? But all of them have been very willing to talk to us and have a conversation, and become more informed of our perspective, as well as now we become informed of their perspective as well, right? Because we come from very different perspectives. They are there to enforce and rule over the law. We are there to fight for our clients and say, she really needs this. Can we just let you know that she really needs it? But again, very different perspectives.
I get it. I have often thought about whether we could have a secret handshake. Signal to judges that we appear in front of regularly, like, this one's for real. I know the one last week didn't seem that urgent, but this one is for real, and I'm doing the secret handshake. Paula, let me ask you a technical question, and I'll explain why. I would like to know whether you think that the faults in the system are faults of the statutes or faults in those statutes application. And the reason that I'm asking is because one sector of our audience after tonight will be college students who are thinking from an advocacy perspective. And so would you, and in a minute I'm going to ask all of you what your wish list is for changes. Leading up to that, what I would like to know in turn, that intern in my office ask, should we be focusing on changing the law, or should we be focusing on changing the way that the law is interpreted? And training judges, doing more training. The law itself is fine, but the judges need to be more trauma informed, or any number of things. In your experience, is it poorly written statutes, or is it poorly interpreted statutes?
Well, do we have 3 hours? No, just kidding. Because we could talk about that for 3 hours, but I'm going to answer your original question. I want to start first with the law has to be applied accurately. And what the difference is, I was a medical malpractice attorney in Chicago and Daly Center for 20 years doing this work pro bono. And now I have the honor of doing it full time for the last several years. And the differences in the actual, and I think we probably all experienced when we got out of law school, when we first went in a courtroom, the difference between what we learned in textbook and then what's in reality. And you have to learn that in each courtroom. I see that very much with domestic violence and sexual assault, the difference. So I think we have to start with the education and the pure application of the statutes that are strong and good, and to make sure they're consistently applied. Then we can get into our group discussion of changes. And I do think, of course, the trauma-informed can always be improved, and it should always be more and more part of a judge's training, because as we know, they rotate so much and there's not really that specialty. And that's what I would like to see changed, but I would love to hear what my colleagues have to say. But that's the answer to your first part of your question.
Okay, Megan, same question. Is it faulty statutes or faulty interpretation?
Well, first, I just want to preface, at Prairie State, I can't advocate for any changes in the law. So I do want to put that out there right now, because I am appearing in my official capacity. But I will say this, in Illinois, we have one of the strongest domestic violence laws in the country. That does not mean that it's perfect. And it doesn't mean that it's going to fit every scenario or work for every person that it falls, that needs help from the court system. It can be a challenge in the job that we do, just as Paula and Jeanette were talking about with the judicial changeover, trying to figure out what are the hot points for this particular judge. What are we going to hang on to and really highlight that is going to make a big impact for this particular person that I'm appearing in front of today? It's made all the harder because these courtrooms are overwhelmed. I mean, the demand on these courtrooms is enormous, and they do not have a lot of time to spend digging into the facts of each particular case. So for example, I was in court yesterday. We appeared in front of our regular order of protection judge, ready to go to hearing, and then we're sent to a different judge. So, and it says log in now to Zoom on this other courtroom. So I have a 30-second phone call with my client where now I am doing different prep on the fly of, this is what this judge is like. This is what you can expect. Try not to let it faze you. We're going to do the best we can. All you got to do is tell the truth. And those kinds of things you just can't anticipate. And I don't think that the law is ever going to be able to solve that on its own.
Jessica, what do you think?
So again, as mentioned, Megan, we can't really advocate for legislation, but I am a former prosecutor, and I will say from the criminal code perspective, Illinois' domestic violence law is quite strong. Not just from the charges, from the Code of Criminal Procedure and what can be admitted. Like basically, you can admit into evidence propensity evidence with prior domestics, the same as you can for sexual assaults. And the legislative history of that suggests that it was intended for the purposes of propensity, similar to sexual assaults. Regardless of how well you write the law, I don't think you're ever going to overcome the human factor of people who are not trauma-informed, people who are not familiar with the law, because until you practice domestic violence law, you may not be familiar with domestic violence law. It's a very specific subset, even within the criminal code. So, I don't know that writing legislation, which I can't, again, I don't want to cross any lines here. Megan's going to throw up the red flag if I do. I don't know that writing legislation is going to solve the problem more than, requiring some sort of trauma-informed training so that people who are in positions of power and who are in decision-making positions can understand why people are responding the way they are, or why things are happening the way they are.
I think that's exactly right. I went to a SANE last year, sexual assault nurse examiner training with Jacqueline Rodriguez from the Attorney General's office, who I think is a goddess. And one of the most important things that I learned about was the neurobiology of trauma. And one of the examples she gave is that when you are going through trauma, it's as if every fact is on a Post-it note, and the Post-it notes are jumbled all over the room. And in testimony, we ask the survivor to put them back in the right order in this way that has been inhibited by survival hormones. I mean, there's a kind of a very important neuro response that happens to trauma. So my wish list would be to follow the science. And I'm stealing that phrase from everybody. Because there is that human aspect that you're talking about is driven by science in some respects, and what happens in trauma is scientific that then might prohibit a survivor from being able to testify in a compelling way that we expect of other survivors of other kinds of crime to be able to testify to. That is something that that kind of training is something that I would change. Jeanette, what is on your wish list? And again, I'm not asking for advocacy of legislation. There's going to be no lobbying here. We are all, members of protected, tax protected organizations. But my question is just, is that a puppy because of that?
That is my cat who was trying to climb on top of my computer because she wants attention. So I am so sorry.
No, we are happy to give her attention. Forget about it. What does your fantasy world look like? Obviously we would love to eradicate domestic violence. Okay. Yes. Work ourselves out of a job. Yes. But within the specific world in which you get up and function every day, what would you change?
Well, I think that, and just going back to what you were saying, I think that we also have to take into account that there's generational trauma, right? So we're not only talking about the trauma that our clients have experienced at this moment, but trauma that has possibly been present through their childhood, through their lives as a whole, right? There's incredible studies of people that have suffered trauma and how that has affected the rest of their lives and their children's lives and their children's lives after that, right? So definitely in a perfect world, everyone will be educated in what trauma is and the impact as a whole, not only immediate trauma of what has happened within the past week, but everything else that has led up to that point, right? Not only for our judges, our attorneys, right? Because as some of you guys mentioned, there's some attorneys that are very rough. Not any of the ones present. I love all of you guys. But they're very, very forceful with our clients, and maybe they do that to intimidate, but they're not aware of the impact that their actions may have, right? In a perfect world, I think that our laws would be proactive instead of reactive, right? Which may be very, very hard to do because you don't want to punish someone for something that they may do. However, if we're talking about in a perfect world, right? Our laws are meant to be reactive at this moment. We are reacting to something that has happened, and it's not focused as much on the prevention aspect of it, right? We have clients that come in and say, well, I'm afraid that he's going to hurt me. And our laws are meant to say, well, if he hasn't hurt you yet, then we cannot help you, right? Because for some people that threat that they know is there may not be enough. So in a perfect world, that's what I would say, right? And I think in a perfect world, I would take into account the fact that it takes a long time for some of our people to come forth, right? They might have suffered this kind of experience a long time ago, and they're just brave enough to come forward and actually share it, which is incredibly intimidating for them. We have to think about the fact that they may be ashamed, they blame themselves. It may be culturally appropriate. There are so many studies of cultures in which if the husband doesn't hit you, it means he doesn't love you, right? So people that are coming over to this country may not know that what is happening is not necessarily what it's supposed to, right? And in a perfect world, right? All of us would be in the same office in the floor of the courthouse where I could just walk over my client and say, here you go, guys. You guys take over. This client needs your help. I would have the sexual assault psychiatrist center in another room, counseling in another room, right? Something where I could actually have all of the resources available for my clients in one spot, instead of having to send them to 20 different people, to 20 different intake processes, in which then they have to retell what has been happening, right? So in my perfect world, all of that is happening right now in my head. And hopefully one day we will all get to be there and have that ability to help everyone the way we want to, instead of the way that we have to because we have limitations.
That's, I want to live in your head. Paula, what's your wish list?
I thought the same thing, Rebecca. I want to live in Jeanette's head because that's a good place to be. I want a world where our victims feel more comfortable stepping forward. They are reticent for all the reasons we've talked about tonight. The abuse not being believed, re-triggering, re-traumatized in the court process again and again by opposing counsel or the judges or the system itself or the criminal process. And as we know, with the linkage between domestic violence and the sexual assault, that exponentially more women who are raped by intimate partners, which is the more common, are more reluctant to come forward. I think I looked up some of these, 23% of those raped by a partner report to the Chicago Police Department, whereas 46% will report a rape if it's a total stranger. My colleague just put out, our policy manager at CAASE, just put out, it was on the cover of the Tribune, the unfortunate report, Too Little Too Late, that of only 10 to 20% of the criminal sexual assaults reported to the Chicago Police Department results in arrest. That in and of itself is a reason our victims are not coming forward. Our survivors are not coming forward. So not only Jeanette's had to, living where they have the tools and resources when we get there, I even want to expand our collective vision that they feel safe enough to step forward, because we know that's been, while it's increased somewhat, it's still so far to go. And we have to create the environment for that, from start to finish, from a detective, from the court to the courtroom, to beyond, to everything like that we do in civil, with like VESA or, employment or Title IX in education. We just have to have, and unfortunately those regulations have rolled back a lot of the progress for survivors, and that could be another whole panel, but those are all the things I wish for. That's one thing I would change. Take the regulations back, these new regulations.
It's hard to look a client in the eye and say, this is worth it. This is going to be worth it. That's so heartbreaking. Jessica, wish list.
I mean, you all have great wish lists, so I think I'll just stick with what you all said. Although I would also, if we could just end systemic racism and intergenerational poverty, that would be great. I think that would solve a lot of our crime issues, as well as our drug abuse issues and our mental health issues. But that's essentially turning the airline tanker in the water. It's going to take another generation to even attempt to resolve that. I would love to see a more trauma-informed system from top to bottom. I'd love to see law enforcement get trauma-informed training. And I'd love to see that go all the way up the chain of command and go to assistant state's attorneys and go to judges and go to public defenders throughout the legal system. But does training really change hearts and minds? I don't know. So let's work on that intergenerational poverty and systemic racism instead. It seems easier.
I'm in. I'm in for those major structural changes. Absolutely. Megan, wish list.
Oh boy, it's hard to go last here. I'm going to take all of theirs. I think I would like to add sort of culturally sensitive services. And I have an advantage anytime I walk into a courtroom as a white woman, right? The services are set up more towards me. You know, that's the way that these things came about, was and an understanding, I guess, that the people who are using the system, those people are the only ones who are experts on their own culture. And what can we do to meet them where they're at and make the systems that we have more accessible to a broader range of cultures? That would be the only other thing I would add at this point.
I think that the most important thing that we do, because I'm horrible at self-care, so I was going to ask a question about self-care, but I have nothing to add to that. And so I didn't want to expose myself as the fraud that I am. So I will just say that the most cathartic for me is to say these words out loud with you women, and to acknowledge our privilege and take a vocal role in ending racism, intergenerational poverty, because if we don't do it, who will? And we, I think, are in a moment where we have the benefit of our relative youth and experience. And if it's not us, who will it be? And that's why I brought my oldest daughter, because if we don't use the words racism and misogyny, if we don't talk about the fact that people walk into Jeanette's office and all of our offices having learned violence from the generation that came before, if we don't talk about how we as you know, and the educated you know, lawyer types, if we don't talk about our responsibility is to ending those systems of oppression, then we can't pass that torch to the next generation. And so, Jessica, I am 100% in your corner, that the way into a better world is to end systems of oppression. And so I'm grateful to be able to talk to each of you tonight, to know that you're in our universe and doing this work, and playing in public and behind the scenes to make life better, you know, one incident at a time. Jeanette, thank you so much for being here. Paula, thank you. Megan and Jessica, thank you guys so much for being here. I'm so grateful to be a woman doing this work with you. This is my self-care. And I'm so grateful for your voices.
So honored to meet you all and to be among with you tonight.
Thank you, Paula.
Thanks for your great work.
Thank you. We will be back for one more panel next week. And we're so grateful for everyone who's taken the time in the future to watch these, start a conversation with your social group about what like people who are the survivors of trauma. Thank you guys all for being here.